What if the most powerful company in the history of the internet was about to be torn apart? Not by a competitor, not by a market crash, not by a scandal, but by the very government of the country that built it. What if the search engine you used this morning, the browser you opened, the ads that followed you around every website you visited, all of it, was built on something a federal judge has now declared illegal? Not once, twice. This is not a rumor. This is not speculation. The courtrooms have already spoken, and Google is running out of places to hide. There's a moment in history when a giant doesn't fall because something outside attacks it. It falls because the ground underneath it finally gives way. We are living inside that moment right now, and most people scrolling through their feeds, watching YouTube, searching Google Maps, clicking on ads, have absolutely no idea what is quietly being decided inside 2 federal courtrooms that will reshape the entire digital world as we know it. The most consequential antitrust battle in technology since the Microsoft case of 1998 has entered a critical new phase. That sentence alone should stop you cold, because most people remember Microsoft. Most people remember the moment the United States government looked at the most dominant software company on earth and said, enough. But that case ended in a negotiated settlement, a handshake, a compromise. What is happening to Google right now is different. It is bigger. It is deeper. And unlike Microsoft, Google has not been found guilty of breaking the law in one market. It has been found guilty in 2. And the second verdict may be the one that changes everything. Let's go back to where this started, because the story didn't begin in a courtroom. It began in a boardroom. Specifically, it began with a single business decision that Google made and then repeated, and then turned into a system and then weaponized across the entire internet over the course of more than 15 years. For over a decade, Google secured its position as the default search engine on browsers, smartphones, and other devices by entering into exclusive distribution agreements with device manufacturers, wireless carriers, and browser developers. Read that again slowly. For over a decade, not a mistake, not an accident, not a market force, a strategy, a calculated, sustained, relentless campaign to make sure that no matter what device you picked up, no matter what browser you opened, no matter what carrier you subscribed to, Google was already there, waiting, default, inescapable. And here is where it gets interesting, because Google did not achieve this dominance through innovation alone. Google paid $26.3 billion in 2021 alone to maintain default search status on devices. $26 billion in a single year, not to build a better product, not to fund research, not to improve your experience, but simply to buy the right to be the first thing you see. That is not competition. That is the construction of a wall, and Google paid to make sure no one could ever climb over it. But here's where it gets worse. Judge Amit Mehta found that Google had unlawfully maintained monopoly power in 2 relevant markets, general search services and search text advertising, principally through exclusionary agreements with distributors. This ruling, handed down in August of 2024, was not a warning shot. It was a conviction. A federal judge looked at everything Google had built, every deal, every default agreement, every backroom arrangement, and said, this is illegal. This violates the Sherman Antitrust Act, the law that was written over a century ago to make sure no single company could strangle an entire market. And yet, Google's stock barely moved. The company issued a statement saying it disagreed with the ruling and would appeal. The tech press covered it for a news cycle. And then the world moved on. That was the mistake. Because what happened next is what nobody was prepared for. On September 2nd, 2025, the U.S. District Court for the District of Columbia issued a landmark ruling imposing significant remedies to address Google's monopoly in general search and search advertising. The word remedies sounds clinical. It sounds bureaucratic. It sounds like something you'd fall asleep reading in a legal brief. But what those remedies actually mean is this. The entire architecture of how Google controls the internet is now being dismantled piece by court order. At the heart of the court order is a ban on exclusive contracts and practices that previously ensured Google's search engine was the default choice on nearly all desktops and mobile devices nationwide. Think about what that means. Every deal Google has with Apple, every arrangement with Samsung, every contract with wireless carriers, every agreement with browser developers, gone, prohibited, illegal. The pipeline through which Google has funneled billions of users directly into its search engine for over a decade, severed. But the Department of Justice was not satisfied. And this is where everything changes. The DOJ's proposed remedies included divestiture, forcing Google to sell the Chrome browser and, if necessary, the Android operating system. Chrome, the browser used by over 3 billion people worldwide. Android, the operating system running on over 70% of all smartphones on the planet. The DOJ looked at Google's empire and said, these weapons need to be removed entirely, not regulated, not monitored, sold, broken off, separated from the mothership and handed to someone else. Google's lawyers called these proposals radical. They called them reckless. Google's VP of Regulatory Affairs outlined potential repercussions of the DOJ's proposed regulatory actions, arguing they would hurt consumers, businesses, and developers. The company painted a picture of innovation collapsing, user privacy disappearing, the open web crumbling, all because the government dared to enforce its own laws. But informed legal observers saw something different in Google's frantic defense. They saw a company that had grown so accustomed to operating without limits that it had forgotten limits existed. And now faced with an actual reckoning, its only argument was, "You cannot stop us, because stopping us would hurt people." That argument has a name. It's called being too big to break. And it is exactly the argument that antitrust law was designed to destroy. Now, Judge Mehta made a decision that surprised many. The September 2025 judgment rejected most of the remedies sought by the DOJ, most notably divestiture of the Chrome browser, but imposed new limits on exclusive contracts and introduced a requirement to share certain data with qualified competitors. The judge stopped short of the nuclear option. Chrome would stay inside Google's walls for now. Android would not be forced to the auction block. For now. Instead, the court imposed behavioral restrictions, a ban on exclusive distribution deals, a mandate to share search index data with rivals so they could actually build competing products. The 2025 Google antitrust ruling is defined more by what it chose not to do than what it did. That is the most precise summary of what happened. And it set off a chain reaction that is still accelerating today, because neither side accepted the verdict. Google filed its notice of appeal on January 16, 2026, challenging the data sharing requirements and technical committee oversight imposed by Judge Mehta's September 2025 remedies decision. Of course it did. Google does not accept any limitation quietly. The company that spent $26 billion in a single year to buy its own dominance was not going to hand over its search index data to competitors without a fight. But here's where it gets worse for Google. The Justice Department in 35 states filed an appeal of the September 2025 court ruling, calling the remedies insufficient and demanding that forced divestiture of Chrome be reconsidered. 35 states. That is not a small coalition. That is not a fringe movement. That is more than 2/3 of the United States of America collectively telling a federal appeals court, the judge didn't go far enough. We need Chrome. We need structural breakup. We need this company dismantled. The DOJ and 38 states filed a formal appeal to the D.C. Circuit, calling Mehta's behavioral remedies a slap on the wrist for a recidivist monopolist. A recidivist monopolist. That phrase carries legal weight that most people do not fully appreciate. It means this is not a company that made a mistake. It is not a company that drifted into anti-competitive behavior by accident. It is a company that has repeatedly, knowingly, strategically violated the principles of fair competition. And a slap on the wrist is not a deterrent for someone who has been slapping the wrist of competition for 15 years. And while all of this was unfolding in Washington, something else was happening in Virginia. Something that most people completely missed. Something that may ultimately matter even more than the search case. Because Google was not being tried in one court. It was being tried in two. The U.S. District Court for the Eastern District of Virginia held that Google violated antitrust law by monopolizing open web digital advertising markets. This is the second conviction. The second federal ruling in less than 12 months declaring that Google is a monopolist operating outside the law. And this one hits at the very engine of Google's financial empire. To understand why this matters, you need to understand what Google's advertising business actually is and how it was built. When you visit almost any website on the internet that runs display ads, something happens in a fraction of a second that most people never think about. An auction takes place. Publishers, the websites that need advertising revenue to survive, put their ad space up for sale. Advertisers who want to reach you bid for that space, and the winner's ad appears on your screen before you've even finished loading the page. Google sits on every single side of that transaction. Google owns the tools publishers use to manage their ad inventory. Google owns the exchange where the auctions happen. Google owns the tools advertisers use to place their bids. Google operates on all sides of the ad transaction: buyer tools, seller tools, and the exchange itself. That's like a stock exchange, also running the broker desks for every trade. Imagine a financial market where the same company owned the New York Stock Exchange, every brokerage firm, and every investment bank simultaneously. And then imagine that company used that position to quietly tilt every trade in its own favor. That is precisely what the court found Google had been doing. Judge Breakup found Google willfully engaged in a series of anti-competitive acts to acquire and maintain monopoly power by entwining its publisher ad server and ad exchange through contractual policies and technological integration. The word willfully is not accidental in a legal ruling. Willful means intentional. It means Google did not stumble into a monopoly. It built one, on purpose. and then used every tool at its disposal to protect it. Breakup previously ruled in April that Google unlawfully monopolized its publisher ad server and ad exchange, critical layers of the open web ad stack, giving the company significant control over how ads are bought and sold online. The entire financial infrastructure of the modern internet runs through these systems. Every news website, every blog, every independent media outlet, every digital publication that depends on advertising revenue to keep its lights on, they are all flowing their money through a system that a federal judge has now declared illegal. And the DOJ was not asking for behavioral changes this time. In closing arguments, the DOJ urged Judge Brinkema to force Google to sell its ad exchange, AdEx, and to open source its auction logic, the algorithms that decide where ads are served. Open source the algorithms. That means making the secret machinery of the world's largest advertising operation public so that competitors, regulators, and independent observers can see exactly what has been happening inside those auctions for the past 15 years. Google's defense was predictably fierce. Its lawyers called a forced divestiture radical and reckless. They argued the systems were too integrated, too complex, too deeply woven into the fabric of the internet to be surgically removed. Google's attorney warned that there is no evidence there would be a buyer for AdEx, and that customer migration would take years, saying that lobbing a grenade like divestiture makes no sense. But the DOJ had an answer for that, and it may be the most damning line uttered in either of these two courtrooms. The DOJ noted that multiple judges have severely rebuked Google for its practice of deleting and suppressing damning evidence, and warned that Google will test every word, every punctuation of a behavioral ruling, whittling away at its actual application until the punishment is essentially nil. This is the argument that may ultimately decide Google's fate in the appeals process, not the technical complexity of divestiture, not the question of who would buy AdEx, but the simple, brutal truth that Google, as a company, cannot be trusted to comply with behavioral remedies, that it has a documented history of destroying evidence, of gaming restrictions, of finding the edges of every rule and quietly exploiting them until the rule means nothing. This is not chaos. This is a company being exposed for exactly what it has always been. Now here is what the financial world does not want to discuss openly. Morgan Stanley analysts estimated in their February 2026 research note that mandatory choice screens alone could cost Google 5 to 8% of its search traffic over 3 years, translating to $15 to $25 billion in annual advertising revenue at risk. A Chrome sale could be even more disruptive, removing Google's ability to channel 3.4 billion Chrome users directly to its search engine. Let that sink in. 3.4 billion people using a browser that feeds them directly into Google's search engine, directly into Google's advertising ecosystem, directly into the financial machine that generates the revenue that funds everything, the AI research, the data centers, the satellite networks, the self-driving cars, the healthcare ventures, the quantum computing labs. All of it flows from one source, and that source is being targeted by federal courts on two simultaneous fronts. Google was found to have maintained illegal monopolies in two separate markets, two separate judges, two separate legal teams, two separate trials, two separate verdicts, both pointing in the same direction. And yet, remarkably, almost impossibly, in January 2026, Alphabet passed Apple in market capitalization to become the second most valuable company in the world, at $385 trillion, sitting behind only Nvidia. How is that possible? How does a company lose 2 antitrust cases in the same year and become more valuable? The answer tells you something profound about how markets work and about what investors are actually betting on. They are betting that the courts will not follow through. They are betting that appeals will drag on for years. They are betting that by the time any structural remedy actually takes effect, the legal landscape will have shifted, the political environment will have changed, or Google will have found a way to negotiate its way out of the worst outcomes. And historically, that bet has paid off. That is exactly what happened with Microsoft in 2001. The government won, the breakup was ordered, and then a new administration came in and the deal was quietly renegotiated into something that let Microsoft walk away largely intact. But something is different this time, something that did not exist in 2001, something that has changed the strategic calculus entirely. Artificial intelligence. The emergence of generative artificial intelligence as a nascent competitor threat to Google's dominance played a key role in fashioning antitrust remedies. The judge looked at ChatGPT, he looked at Perplexity, he looked at what Microsoft had done by embedding AI into Bing, and he concluded that maybe, just maybe, the market was already shifting, that the wall Google had built might be cracking from the outside as well as being torn down from within. This reasoning is simultaneously hopeful and dangerous. Hopeful because it suggests competition is emerging organically. Dangerous because it gave Google an argument to escape the harshest penalties. If AI is already disrupting your monopoly, the court reasoned, Perhaps we don't need to go further. But what informed analysts are watching closely is whether that AI disruption actually materializes fast enough to matter. Because right now, in mid-2026, Google still controls over 90% of the global search market. 90%. Despite ChatGPT, despite Perplexity, despite Microsoft's billions of dollars in AI investment. Google still owns the search market the way no company should ever own anything in a functioning competitive economy. And here is what most people are not seeing. The appeals court arguments are projected for late 2026 or early 2027. The D.C. Circuit Court of Appeals is expected to hear arguments in late 2026 or early 2027, and most legal analysts believe Chrome divestiture remains on the table despite the district court's rejection. That means the most significant decision, whether to force Google to sell the browser that 3 billion people use daily, has not yet been made at the appellate level. The district court said no. The DOJ is appealing. The circuit court gets to decide whether the lower court was right. And in Virginia, the AdTech Remedies ruling is still pending as of the time of this script. Judge Brinkema raised concerns over the impact of Google's expected appeal, which would significantly delay structural remedies in what is likely to be one of the most significant government interventions in the ad market. She is weighing a decision that could force Google to sell AdEx, the engine that processes millions of advertising auctions every single second of every day, with the full knowledge that whatever she orders will be immediately appealed, potentially delayed for years, and fought at every step by a company with virtually unlimited legal resources. The DOJ's argument, the one that may ultimately resonate with appellate judges more than any other, is built not on economics and not on market theory, but on something simpler and more alarming. It is built on character. Google will test every word, every punctuation of a behavioral ruling, whittling away at its actual application until the punishment is essentially nil. You cannot regulate a company that will not be regulated. You cannot impose behavioral restrictions on a company that has a documented, court-verified history of deleting the evidence of its own behavior. At some point, the only remedy left is structural. You don't reform the behavior, you remove the power that makes the behavior possible. And this is the question that will define the next decade of the technology industry. Because Google is not being tried in isolation. What happens to Google becomes the template. Amazon is watching. Apple is watching. Meta is watching. Every dominant tech platform on earth is watching these two courtrooms, waiting to see whether the United States government has the institutional will to follow through on its own antitrust laws. Amazon and Apple antitrust cases are pending, with trials expected in 2027. Those cases will test whether courts continue the pattern of finding violations but declining breakups, or whether the legal environment changes. What is happening to Google right now is not just a legal story. It is a civilizational question about who controls the infrastructure of modern life. Search is not a product. It is the interface through which billions of people access knowledge, make decisions, navigate commerce, form opinions, and understand the world. Advertising is not a market. It is the financial oxygen that keeps the entire open web alive. Whoever controls these systems controls the architecture of information itself. And right now, a company that a federal judge has called a recidivist monopolist, a company that has deleted evidence, paid billions in secret deals to maintain its dominance and operate on both sides of every market it touched, controls 90% of global search and the majority of the internet's advertising infrastructure. The courts have spoken twice. The Department of Justice, joined by nearly 40 states, has filed formal appeals demanding structural breakup. The circuit court arguments are coming. The Virginia AdTech remedies are imminent. And Google, despite its astronomical market cap, despite its armies of lawyers, despite its lobbying power and its political connections, is for the first time in its existence facing a genuine, legally grounded, institutionally backed threat to its structural integrity. This is not the end of the story. It is a new, complex beginning. It will set the stage for how the U.S. legal system handles monopoly, innovation, and competition in the AI era. But the outcome is genuinely uncertain. That is the part that no one can honestly tell you with confidence. Will the D.C. Circuit order Chrome divestiture? Will Judge Brinkema force Google to sell AdEx? Will Google negotiate a settlement, as Microsoft once did, and walk away from this with behavioral restrictions it can quietly dismantle over time? Will a change in administration shift the DOJ's appetite for this fight? Will AI genuinely disrupt Google's search monopoly before the courts can act? Will the appeals process drag on so long that the entire digital landscape transforms before a single forced divestiture ever takes effect? The honest answer is, nobody knows. What we know is that 2 courts have already declared Google a monopolist. What we know is that the DOJ and nearly 40 state governments believe the current remedies are insufficient. What we know is that a company which controls 90% of global search has been told, by the law, that how it built that control was illegal. What we know is that the appeals process is now active, escalating, and moving toward a reckoning that could be the most consequential antitrust outcome since AT&T was broken apart in 1984. And what we know, perhaps most importantly, is that what happens next will not just determine the future of Google. It will determine whether the internet remains a space where dominance can be legally purchased for $26 billion a year, or whether the law finally draws a line and holds it. The courtrooms are still open. The appeals are in motion. The judges are deliberating, the governments are pushing, and Google, the company that once told the world, "Don't be evil," is now being told by federal courts twice over that it was. What comes next is not written yet, but it is being written right now, and the world is watching.